Does somebody have a question, sir?
No,
So I got an email this morning saying you were updating something.
just the request because it was an all-day meeting instead of just a 7 o'clock meeting.
Listed for all day, so
Oh, gotcha.
I'd like to meet for 24 straight hours.
I think I don't feel very well. Is that a good excuse?
Oh, 3 months in a row. That's impressive.
Sometimes.
Waiting to connect up to my internet.
Oh, that'll help. But who's missing here? Oh, Raylan. What's the timer watch for?
So that is for.
Really? You had to get down to that?
I don't know the background, but I think it's made everyone on.
Okay.
A little more but if you would like.
I heard some rumor that in some ancient culture, they had this practice where you had to stand on 1 foot while you were speaking. Keep people from talking too long. I don't know if it's true or not, but I love the idea. I had a friend I always thought should do that.
That's in the bylaws yet.
Haven't started. That doesn't mean I'm not glad about you, but I'm just, you know what I mean? Ah, goodness. After the meeting, can you stick around for a minute? I got a couple things to ask you. Lately, I've noticed more people have been having trouble with the Wi-Fi.
I already checked on it.
You are on it?
This is like the first time
Oh.
I'm
Okay.
You went to the webpage and then.
No, I never actually used their Wi-Fi because it's too slow. I used my
Oh.
phone. It wasn't taking me forever to recognize my phone as a hotspot. But now it's hooked up. All right, can you need a minute, Raylan? You ready?
I'm ready. Let's don't stop on my phone.
Oh. All right, this is a meeting of the City of Ferndale Board of Zoning Appeals. The date is October 19th, 2021. Meeting will come to order at 7:10 PM. The Board of Zoning Appeals is a quasi-judicial body authorized by Section 24-421 of the City of Ferndale's Code of Ordinances. The BZA is a body of limited powers. We are restricted by the City of Ferndale zoning ordinance and by Michigan law. The BZA is authorized to interpret the zoning ordinance and the zoning map, to hear and decide appeals of decisions made by administrative officials or bodies charged with enforcing the ordinance, and to analyze variance requests as permitted under the ordinance. The BZA does not have the power or authority to amend the zoning ordinance, or to disregard its provisions, or to rezone parcels of land. Changes in the ordinance must originate with City Council, not with the BZA. Let's do a roll call, please, Jordan.
Board Member Blazinski. Councilmember Leaks May.
Here.
Councilmember Colson. Board Member Colson. Board Member Monk.
Here.
Board Member Palmer.
Here.
Board Member Steidemann.
Here.
And Chair Williamson.
Here. So we have everyone here except for Colson. Justin, did we receive any advance notice from Austin that he wouldn't be with us tonight?
We did.
All right, in that case, I would entertain a motion to excuse the absence of Board Member Colson.
So moved.
Seconded.
Moved by Board Member Palmer, second by Board Member Steidemann. Let's do a roll call vote on this.
Councilmember Leaks May.
Yes.
Board Member Monk.
Yes.
Board Member Palmer.
Yes.
Board Member Steidemann.
Yes.
Board Member Blazinski. Chair Williamson.
Yes, that motion passes. All right, next up, we have approval of the agenda. Has everyone had a chance to take a look at tonight's agenda?
I'd like to make a motion to approve the agenda as written.
Support.
Motion to approve is written by Board Member Palmer, support by Councilmember Leaks May. Actually, instead of roll call, let's just do it the easy way. All in favor, please say aye.
Aye.
Any opposed? Hearing none, that motion passes. And that takes us on to item 3, which is approval of the minutes. Has everyone had an opportunity to review the minutes from our BZA meeting that took place on September 21st, 2021? And I will take this opportunity to remind board members that you need not have been present at the meeting in order to vote for or against approval of the minutes.
I move that we accept the minutes as presented from the September 21, 2021 meeting.
I'll second it.
Okay, motion by Councilmember Leaks May, seconded by Board Member Palmer. All in favor, please say aye.
Aye.
Aye. Any opposed? Hearing none, that motion passes, and the minutes of September 21st, 2021 are approved. Next item on our agenda is the call to audience. At this time, any member of the audience who would like to come forward and speak to the BZA on any item that is not already an agenda item on tonight's agenda, please feel free to do so. Seeing none, we'll move past the call to audience to our regular agenda. And what we have on the regular agenda tonight is consideration of an administrative decision at 1461 East 8 Mile Road, which is the Motor City Pawnbrokers. Based on the materials that we have been provided by staff, we have a differing interpretation of the zoning ordinance by city staff and by the applicant. We have a staff report that's been provided setting forth the city's position. We have a letter from Community Image Builders that has been provided on behalf of the applicant, setting forth the applicant's position. And our body is being asked to review both of these positions and provide an interpretation of the zoning language at issue. It appears that the primary issue, and Justin, please correct me if I'm wrong on this, it appears that the primary issue is whether a proposed amendment to a conditional rezoning agreement can be immediately submitted to City Council for review, or whether the applicant must first wait a year, resubmit the agreement to Planning Commission, and secure a decision from Planning Commission before going to City Council.
Generally, yes. Just for the record, Justin Lyons, Planning Manager for the city. Good evening, Chair Williamson and board members. But generally, yes. So section 24-323D, subsection D, references petitions for rezonings, text amendments, or master plan amendments that have been denied by city council or planning commission shall not be resubmitted for a period of 1 year from the date of denial. And there's some additional text there. And so, for this particular project, it was approved for a conditional rezoning in the past in 2015 by city council. So more recently, the applicant submitted a amended conditional rezoning agreement. And so the general process in the zoning ordinance is to follow the same process. So we scheduled a public hearing at the planning commission, and that's where there was a 4-4 vote, and so the motion failed. That's just a little additional background from the staff report, but also just wanted to note City Attorney Dan Christ is here as well to fill in any gaps that I might have missed.
All right, if the city attorney would like to provide some additional background on the city's position, we'd like to hear that now, and then afterwards we'll hear from the applicant.
Thank you, through the chair. As Planner Lyons indicated, I believe the crux of the appellant's argument is twofold. One is the issue of whether or not in the face of the Planning Commission denial of the motion to amend the conditional rezoning agreement, there is a requirement that he wait, or the applicant wait for 1 year prior to resubmitting an application for a conditional rezoning amendment. And then I believe that there is also an argument that is being raised as to the language for a conditional rezoning in Chapter 24, 325, specifically C4, which provides that if a conditional rezoning agreement has been offered by the applicant and recommended for approval by the Planning Commission, the City Council may approve the conditional rezoning agreement as a condition to the rezoning if it meets all the requirements above. The city's position is that the Planning Commission in this instance did not recommend for approval the conditional rezoning agreement or the amendment to the conditional rezoning agreement, and that the lack of that affirmative recommendation by the Planning Commission is a predicate to City Council considering the rezoning amendment to the rezoning agreement. The city's contention is that the normal rules of statutory construction would provide that every word has meaning, and that to cut out the language that says in subpart 4, where it's been recommended for approval by the Planning Commission, and hold otherwise that City Council can still consider the amendment to the rezoning where the Planning Commission has not recommended that amendment, is inconsistent with the plain language of the ordinance statute or the ordinance, and obligation of this body is to, in considering the zoning ordinance, determine what the actual intent of the ordinance is. And again, the rules of statutory construction would be that every word has meaning, and when you apply that statutory construction, the meaning is apparent that the recommendation from the Planning Commission is required before council can consider the amendment to the rezoning. I said rezoning. Consider the amendment to the rezoning agreement, the conditional rezoning agreement. Certainly, if any of the board members have any questions with respect to that position, I'm certainly happy to expound further, but at this point, I don't have any additional comments at this point.
Okay, I'm sure we will have some questions. Thank you. And now let's hear from the appellant. If you'd like to approach the podium, introduce yourself, and quickly walk us through your arguments.
Okay.
I think we have heard some interpretations of your position, but
Right.
I want to be sure that we're hearing the specific position as you would state it.
Sure. Thank you very much. I'm Carmen Aventini with CIB Planning, and you have the letter that I submitted. Mark Aubrey could not be here tonight. He had a charity fundraiser to attend, so I'm here to present on his behalf. And I think the primary difference that we have in terms of interpretation is we're of the opinion that only Section 24-325G, conditional rezoning amendment of the ordinance, in the section that says the conditional rezoning agreement may be amended by the city council with the property owner's consent in the same manner as was prescribed for the original rezoning and conditional rezoning agreement. So for those who were involved at the time, we went to the Planning Commission, and we were actually recommended for denial by a 5-4 vote. We then went to the city council, and at that point in time, Mr. Aubrey offered up some additional conditions that led to one of the council members as the liaison to the Planning Commission. She changed her vote based on those additional conditions that were offered, which is a totally appropriate approach. So what we're looking for is merely to follow the same process that we followed before, and that was actually recommended for denial, okay? We're of the opinion that the other section that's being cited, which is section 24-323D, is not really applicable here. And the reason is that we're not petitioning for a rezoning. We've already done that. Okay, we've gone through that process. We just want the council to act on. They may deny it. They may approve it. We don't know. But at least to be able to present it to the council and let them make that decision. So we're not applying for rezoning, we're not applying for a text amendment, and we're not applying for a master plan amendment. Now, but if you do look at that section, it does say petitions for rezoning, text amendments, or master plan amendments that have been denied by the city council or planning commission. Okay, the first two, the rezonings and text amendments, they can only be denied by city council. Planning commission merely recommends the city council. The master plan amendments can be denied by the planning commission, okay? Depending on whether city council has decided to retain authority over adoption of the master plan or not. Okay, some communities it's strictly with the planning commission. So it's calling for, it has to have been denied by one of those two bodies, and in this particular case, only the rezoning, if this were applicable, only the city council could deny it. So when you look at the strict writing of that section, they can only deny it. The other point I'd like to make too, and then I'll answer any questions you have, is it was a 4-4 vote, and it was a vote based on a recommendation. It was not based on approval. And if it's a 4-4 vote for a recommendation, it's just no recommendation, basically. It's a 4-4 recommendation. The Planning Commission did not have approval authority in this particular case. They were only being asked to recommend to City Council. So just like when we went for in the original rezoning, where it was actually a recommendation to deny, we just want to follow section, 325G, that says that it would be a recommendation from following the same procedures from Planning Commission to City Council. So it's all we're looking to do is follow that same process that's called for in here. And probably our biggest disagreement is that that other section, 323D, even applies in this case. So that's our position, Mr. Chair, and if you have any questions or any additional thoughts, I'll be happy to talk through them with you.
Okay, thank you. I think we'll probably have some questions for everyone. I'd like to start with the city. Looking at section, the language of section 24-325G, it says the conditional rezoning agreement may be amended by the city council with the property owner's consent in the same manner as was prescribed for the original rezoning and conditional rezoning agreement. Got a reference here to both the original rezoning and conditional rezoning agreement request. Within the same statute, 24-325C, you have a process for evaluating a conditional rezoning in a Why is the city looking to 324-323 and not 320 or 24-325C here?
Why are we looking at 325?
You're looking at 323D, and he's asking why you're not looking at 325C.
Right.
We're looking at 325, subpart C, which is the process,
In our, it says,
and then subpart 4.
Okay, based on the staff report that we got, the reference is really to section 323D, and there isn't really any discussion of the process provision from section 325. Under subsection C2 of 24-325, it does say that the conditional rezoning agreement may be submitted prior to Planning Commission making its recommendation to City Council, and that it shall be reviewed by the city attorney.
That's right.
Is that what's happened here? It's
No.
been submitted?
No. What that is referring to is a proposed, remember, in a conditional rezoning, it's the applicant that sets forth various conditions, and the city is not able to require the conditions for conditional rezoning under the Michigan Zoning Enabling Act. And so, in order to determine whether the proposed conditional rezoning agreement is in the appropriate format as required by the Michigan Zoning Enabling Act, that's why that language is there. So that presumes that it would be reviewed as to legal form and as it relates to the requirements under the Zoning Enabling Act for conditional rezoning. As it says, that the second sentence of C2 says that the conditional rezoning agreement shall be reviewed by the city attorney at the expense of the applicant to determine that the conditional rezoning agreement conforms to the requirements of the section and the zoning act, and shall confirm that this conditional rezoning agreement is in a form acceptable for recording with Oakland County Register of Deeds. That's just as it relates to the format of that proposed conditional rezoning agreement. But that's not what happened here. What happened here is that an amendment to the approved conditional rezoning agreement was submitted for review. So if you look to the language of G, which is amendment, that is considered in the same manner as was prescribed for the original rezoning and conditional rezoning agreement. And what happens at the original conditional rezoning agreement is the Planning Commission weighs in and makes a recommendation consistent with what I had identified, which is C4 as to the process. And that language of that section says it doesn't require the Planning Commission to recommend or not. It says that it may, but it conditions council's approval on a positive recommendation from the Planning Commission.
Wonky, you're actually getting into my next question, which is this. Under 325C3, it says, following the public hearing for a proposed zoning amendment, the Planning Commission shall make a recommendation to City Council based on the criteria listed in Section 323. Now, I understand we're talking about an amendment to a conditional rezoning agreement, but because we have a requirement that we basically walk back through the same process that we used for the initial
Rezoning.
additional rezoning, it appears that's what happened here. The Planning Commission, at a public hearing, the Planning Commission did consider this amendment as though it was considering a new conditional rezoning agreement. But what I'm not seeing is I'm not seeing a recommendation from the Planning Commission. And I see that being required in 325C3, and if I look at 323B, it also says, following the public hearing, the Planning Commission shall identify and evaluate all factors relevant to the petition and shall report its findings and recommendation to the City Council. So what I'm wondering is, in the current situation, how does the Planning Commission make a recommendation and report its findings to City Council?
Well, it did so by virtue of the denial of the motion to recommend the amendment to the conditional rezoning agreement. And since the language of C4 requires the approval, it doesn't go forward. Now, the ordinance could have been drafted in another manner. It could have said, you know, it could have been fashioned in a way that did not require the approval of the Planning Commission. It could have said that it just had to be considered by the Planning Commission, and that the City Council could then accept or reject, similar to other ordinance recommendations that the Planning Commission makes. It has discretion sometimes to accept or reject. But this is a conditional rezoning, which is inconsistent with the master land use plan, which has been adopted by the city. And the Planning Commission spends a tremendous amount of time with that master land use plan. And so, while I don't necessarily have any legislative insight as it relates to this, it makes sense for a conditional rezoning, for the Planning Commission to have that extra authority with regard to an amendment to a conditional rezoning agreement.
Although there hasn't been a motion that the Planning Commission has passed to recommend a denial, it's the city's position that that's unnecessary, and that just by failing to pass
Well,
to recommend approval,
there would, yes.
it's the same thing as approving a motion to deny.
Yes,
So a split vote without a majority is considered a denial.
yes.
At least that's what the city is. That's what the city's position is. And you know, let's have any other questions that council members have for the city, and then we'll have questions for the applicant as well.
Can I just ask the question related to the point that you guys were just on about Planning Commission makes, we did find the language in the code that said Planning Commission makes the recommendation to council. So if we interpret it as the city is currently, if it doesn't go on to a council agenda, then how does council become aware of the recommendation that was made?
Well, it, by virtue of the minutes that are publicly available to the public and council. But the city's argument and position is that council doesn't get to consider the proposed amendment to the rezoning, conditional rezoning agreement until the Planning Commission recommends it.
Okay, and then follow-up question, so then in the city's opinion, as I heard the applicant state, it's his opinion that only council has the authority to deny the amendment. In the city's opinion, who has the authority to deny the amendment?
In the city's position, the council does not get to consider the amendment absent a Planning Commission recommendation for approval. So there would be, at this point, a denial by virtue of the Planning Commission not recommending.
So, if I may, Attorney Chris, I'm looking at this and I'm thinking like I was just pretty much the new kid on the block, not even sworn in yet for this one, but what I'm thinking is that, so why am I thinking there have been times when something has come to city council that hadn't gone to planning? Is that,
Not for, well, I'm not sure, through the chair, I'm not sure in what context you're considering that. I mean, as it relates to zoning ordinance amendments, there is a requirement that it be considered and have a public hearing be considered by the Planning Commission prior to an ordinance amendment, but I'm not sure if that's what you're referring to.
so maybe I should, Justin, maybe I should, so I'm just asking, have there been, and forgive me if I don't remember, have there been situations where it was a situation where it did not go through planning commission, but did come to city council and kind of bypassed planning commission?
Not that I can think of. I mean, there are certain times where like, alley vacation or something like that goes directly to city council. There's certain things that council reviews, but,
Okay.
not for any of the recent, plan unit developments or
Right.
rezone,
Okay.
special land uses that I can think of.
I'm looking at a set of council meeting minutes from August 24, 2015. And one of the items on the agenda here was consideration of Motor City Pawnbrokers' appeal of rezoning denial. If the original conditional rezoning request with the conditional rezoning agreement, the Motor City Pawnbrokers submitted back in 2015 was denied at the planning commission level, how did this ever get before city council?
Yeah, well, there is an inconsistency over the past review of this section by the council, or by the city, and that is clear. But in reviewing the language of the ordinance, a mistake with respect to the implementation of an ordinance in an instance is not a bar to the board or the city from requiring the ordinance to be followed in a subsequent instance. The city is not equitably stopped from the proper application of its ordinances because there may have been some ministerial error at some point in time.
Okay, so the city is not, the
city's not
position
barred.
isn't that this has never happened before. The city's position is that if it has happened before, it's not consistent with the ordinance, and the language of the ordinance isn't vacated just because of the fact that some past administrations have not understood the proper application.
Through the chair, that would be the argument with respect to that.
Okay, so that's the city's position. Thank you.
Thank you for bringing that to our attention. Did anything happen at that council meeting?
At this council meeting, this is where Mark Aubrey noted his willingness to submit to a deed restriction agreement not to have more than one location in Ferndale. There were some residents that spoke for the rezoning and then some that spoke against the rezoning. And then there was a motion by Councilmember Lennon, supported by Councilmember Martin, to approve the rezoning request.
They ultimately, there was additional conditions made at that council meeting, which council ultimately accepted, and that's the conditional rezoning agreement
It's
before,
existing.
The deed
that
restriction.
right here is before, which is being proposed to be changed again.
Gotcha.
Right, so the applicant's in a position where they have already done this once, and they're wondering why they can't do this again, because they already did it once. And the
But they're
city's,
making an amendment, which means a change.
right, the city's position is that there is statutory language that wasn't followed the first time around, and that doesn't mean that it's invalid just because it wasn't properly followed the first time around. Let's, do we have further questions from board members for the city at this point? I want to give everyone an opportunity to ask questions of Attorney Chris, who we appreciate you appearing for us and answering the questions. And it's going to be much easier for us to understand what happened and what's going on with your input. So we have Attorney Chris here to answer questions. We have Justin to answer questions. So any additional questions from board members?
Bless you.
Through the chair, I just wanted to, I wasn't sure if I know that it doesn't appear to be anyone here for the public hearing. I wasn't sure if you opened it and closed it, but just wanted to make sure that was, I might have missed it if you did.
No, I appreciate the reminder, Justin. After we finish with questions for the city, we'll do a quick public hearing before we move on to the applicant.
I'm just curious, I know it probably just doesn't completely pertain to today's case, but I just want to make sure I understand. So originally, Motor City Pawnbrokers was rezoned, it was office service. I think their one building is like, must be a C3 then, right? So that they can be a pawn shop? What are they trying to rezone to now?
What's the change?
What are they asking for?
I don't know if you want me to answer that or the chair.
Well,
Whoever knows.
Let's have Attorney Chris to answer the question.
through the chair, it's my understanding the proposed amendment deals with a condition that was made at the council meeting where the conditional rezoning agreement was approved, which would eliminate or preclude the applicant from displaying firearms in the showroom of the particular location. It's that change that is, I believe, the substance of the amendment now, which is to remove that condition that was previously made, to allow for firearms to be displayed in the showroom.
So,
And if I misstated that, yeah, please clarify that if I have that slightly wrong.
through the chair, there would be no difference in zoning, it'd still be, I'm assuming a C3 or whatever it is now,
Yes.
and it wouldn't change at all, they just want that, those handcuffs removed on that one provision?
Correct.
Is that, so that's considered a rezoning, just to have?
It's considered an amendment to the rezoning agreement.
Ah, okay.
Because it was a condition to get the zoning approved in the first place.
Gotcha,
It was a condition to not show the fire.
okay. So that's why you were doing 324, or 325G, got it.
So if I may, through the chair, is that why city council approved it, because the firearms would not be shown?
Through the chair, that was the additional condition that council, that the applicant offered and which council accepted to approve the conditional rezoning back at that time. Well, I'm not sure if it was 2015 or 2016. And,
2015, yeah.
through the chair, Mr. Lyons may know, my recollection is there may have been some votes prior to the final vote where, where the applicant ultimately got approval, where the applicant didn't have approval until that condition was finally added.
Yeah, there was another vote on November 23rd, 2015, where the conditional rezoning agreement was approved at that point. There was some discussion at the August meeting where the multiple conditions were added, including, it looks like primarily the deed restriction that they would have not had more than one location, and then all of the other conditions aren't listed out, but it notes that there are additional conditions, including submitting a security plan as part of the agreement.
So just to, may I finish my
Oh, yeah,
questions
if you have more, I
before?
was just gonna ask if there are more questions for city staff. Let's
Yeah, so of the two requests, to sort of, just so I can close my mind around the first request, is that there's this discussion about a 4-4 vote not being a denial, it's not a, I mean, I'm under the understanding it has to be a simple majority in order to be then moved on to city council. So the planning commission didn't have a simple majority, therefore it does not move on to city council. Am I understanding the request number one correctly?
Yeah, through the chair, that's the city's position, yes.
Okay, and then request number two is that this can't be brought up for another year, and they're arguing that they want to be able to bring it up with faster than a year. Am I understanding that correctly?
Through the chair, I think there's additional language with respect to the section that normally would require a year. I don't have it at my fingertips. There are, one of those is additional facts. Justin, do you have the section so I can read it?
Section 24-323D. Petitions for rezonings, text amendments, or master plan amendments that have been denied by the city council or planning commission shall not be resubmitted for a period of 1 year from the date of denial, except on the grounds of new evidence, materially revised request, or proof of changed conditions relating to all of the reasons noted for the denial found to be valid by the planning commission.
Those were the other exceptions. I knew there were some exceptions.
I guess I'm confused. It wasn't denied.
Well, but through the chair, I mean, if we don't,
Hold on just a minute, board members. before we get into this discussion, I understand exactly where this discussion is going, and I think we need to have it, but I want to make sure that we get through all questions of the city, get the public hearing done, and then question the applicant, and then get into board discussion about the different positions. So if you'll keep those thoughts in mind, Board Member Palmer, I know exactly what you're going to want to raise here, and I'm interested, Board Member Steidemann, to hear your position on this as well. But I want to make sure that we have, that everyone's had a chance to ask all the questions that they want before we get into a substantive discussion. So, with that said, does anyone have further questions for the city at this point? Okay, seeing none, let's do a quick public hearing at this point. We're going to open a public hearing on this issue at 8:15. Any member of the public who has any opinion that they would like to make known to the board, please step forward and do so. Justin, if you can let us know whether anyone has weighed in via email or telephone or anything else, that would be great. 7:45.
To the chair, nothing that, no one contacted me via email, letter, or phone.
Okay, thank you, Justin, and Board Member Blazinski, thank you for correcting me that it's actually 7:45 and not 8:45. Thank God it's not already 8:45 at this point. We'll close the public hearing at 7:46. And now, if the applicant would like to, or appellant would like to come forward again, that would be great, and we'll ask you any questions that any of the board members have of you at this point.
Thank you.
So I'd like to start with a couple. Let's see. You've argued, as part of your arguments, or one of your arguments, that a 4-4 vote for recommendation to council means no recommendation, while a 4-4 vote for final approval means denial, so that this is actually not a vote to deny. But you've also argued that you were able to get to the city council previously because the request had been denied and you were appealing it to city council. If you were going to have the same process in this situation that you had before, wouldn't you need either an explicit approval or an explicit denial in order to have the same process?
Well, I think the key here is the terminology. I mean, the Planning Commission, if you look at the state act, Michigan Zoning Enabling Act, there's nothing in there that gives the Planning Commission any kind of approval authority over rezonings, none whatsoever. The Planning Commission can only recommend, and that's what I'm saying, when it was a 4-4 vote, it was a 4-4 vote to recommend, well, no recommendation. Previously, it was a 5-4 recommendation to deny. And I know this because I teach this for MEDC, the Redevelopment Ready Communities Program. You're certified under that program. All of the people that you sent through, I taught the zoning part of it. So, I mean, I've spent 38 years dealing with this, and there's just something fundamentally wrong with expecting a planning commission to have any kind of approval authority over rezoning. It's not there. You can approve a site plan, you can approve a special land use, but you can't, they don't have approval authority over rezonings. So it's merely a recommendation. And by saying you have to wait, and remember, based on a denial, there was no denial, it's a recommendation to deny. So by making somebody wait 12 months, it's a de facto denial. You're basically saying you're denying them. And the Planning Commission just doesn't have that authority. So,
very knowledgeable about this, and I appreciate all the knowledge that you're bringing, but I also would note that you haven't really provided us with any authority aside from your own knowledge in your head as to this issue. Do you have any citations that you could give us? I mean, is there anything that you can give us besides your own personal knowledge that the Zoning Enabling Act does not permit the Planning Commission to require a 12-month delay if the Planning Commission doesn't specifically recommend approval?
yeah, if you look at section 125.3202 of the Michigan Zoning Enabling Act of 2006.
Okay, I'm going to ask you to hold on for a minute.
Sure.
You actually provide this to us, so we're going to have to look this up.
Sure.
Can you repeat the number? Did you say 125.302?
Yeah.
Yes.
enabling.
Okay, you said MCL 125.302?
Yes.
Okay.
Actually, I think, I'm sorry, it's 125.3401 goes into the details of the voting and refers to the legislative body making the decision and the recommendation coming from the Planning Commission. Yeah, 3202 talks about amendments, that you follow the same procedure as the original adoption.
Okay, I see in subsection 5, it states a zoning ordinance and any amendment shall be approved by a majority vote of the members of the legislative body. Is this the language that you are relying on?
Yes.
Support the proposition that the planning commission is not legally able to require a 12-month delay?
Correct.
Okay, do you have any authority that supports the concept that a 12-month delay is equivalent to a denial?
Well, I mean, it's common sense that if you hold somebody up for 12, the whole reason for the 12-month requirement in there is to keep folks from wasting the time of the body, so they don't get denied and then they come back the next month and they try to wear you down. That's the whole intent behind it. But if we're going to say that the Planning Commission, a recommending body, and once again, you're interpreting here, that the Planning Commission, a recommending body, has the ability to make you wait for an entire year based on a recommendation and not having final approval authority in a rezoning case, then it's basically the same thing as saying we're denying you. And if I could add to that too, if that were the case, that they did have some kind of approval authority, wouldn't it be like this body here, where you mentioned beforehand that you need to have, you know, we don't have a full complement of board members, there's only 8 instead of 9, and wouldn't you warn the applicant beforehand and give them the opportunity to table until you have a full complement of board members, knowing that you could end up with a 4-4 vote? It's just the whole concept of anything other than a recommendation coming from the Planning Commission is just not supported in state law. I've never seen that in my entire career, where a Planning Commission has the ability to hold an applicant up on a rezoning for an entire year.
For those of us that aren't lawyers, can you clarify what the legislative body can or does represent in the Zoning Enabling Act?
I'm sorry, could you say that again?
Would someone care to maybe explain what the legislative body can or is allowed to be composed of? Like, does it have to be elected? Does it have to be, can it just be put in place? Can it be nominated by an elected body? Does it, like, I guess I just want to understand the rules around the legislative body.
We're not a
Legislative body is council.
Yeah, it's council.
Body that's,
Elected.
So the planning commission would not be a legislative body because it's not voted and elected by the populace. Okay, just wanted to clarify. Thank you.
you don't have the authority to change the ordinance.
I would call your attention, since we're looking at 125.3401, subpart 3 does say that the legislative body may refer any proposed amendments to the zoning commission for consideration and comment within a time specified by the legislative body. And I would just argue that that goes to what council has done via the adoption of the zoning ordinance, which is prescribed this to the planning commission. also just fingertips, but the language on conditional rezoning approval under the Zoning Enabling Act, I'm going to get it for you, but the last section of that indicates that an applicant does not have any rights with respect to the conditional rezoning agreement. It's a discretionary act. It's a discretionary act.
Like the full sentence before
Well,
that. They don't have any rights with respect to the.
they don't have any inherent rights to a rezoning. It's conditional, and it is at the discretion of the municipality to accept or not.
Mr. Chairman? Yeah, I agree with the attorney. I totally agree. If Mr. Aubrey wants to make his case that it's safer for him to have guns in the case rather than bringing them all out to show people, that's a discussion that he and the elected officials should have, because they're the ones who are going to hear from the residents who live around there, and they were the ones who were primarily concerned in the beginning about the guns, and it was based on safety. So we're just saying he'd like to have that conversation with City Council and discuss that. The Planning Commission's an appointed body, not an elected body. They're kind of insulated from the public to an extent. If they're not happy with the Planning Commission, they can't vote them out. So we're not in disagreement in terms of, it really, the only thing it comes down to is that 12-month wait. We just are of the opinion that it wasn't a final decision, and so therefore it's a recommendation, therefore it should go to City Council. And if they deny it and they don't want to do it, then absolutely, City Attorney is absolutely correct. You're not required to give that, but he would at least like the opportunity to have that discussion and think it through very thoughtfully so that consideration can be given to all the things involved here. I mean, I took a visit to the facility, I walked through it, and I can see where having, a number of guns out at one time is much less secure than if you have them locked in a case and you can take them out one by one. But irregardless, that's a conversation that he needs to have with City Council, whether they approve of that or deny it. So we're just of the opinion that making him wait for 12 months is basically saying no, and we don't think the Planning Commission has that authority.
Okay, let's have further questions from board members to the appellant. Board member Steidemann.
This was the one to the appellant, though.
Oh, okay, that's fine. If you need clarification on something, that's fine as well. I just want to.
Okay, yeah, so just for clarification, there was a discussion earlier about how there's a rule somewhere, and I missed where it was. I didn't write it down, so if someone could point me in the right direction. Where was it written that in order for it to go before City Council, it had to be passed by the Planning Commission?
It is 24-325C4.
Okay, and does that supersede the MCL 125-3401? Like,
No, the state law supersedes the municipal law, but what the city's argument is that these are consistent, and the appellant's argument is that they're not.
Okay, now I'm on board, thank you.
Through the chair, I guess I could ask this. So, from the city's perspective, the city considers this to be a denial. So from the city's perspective, following that, what are the applicant's options?
Through the chair, I think that that falls back to I forget the section and subsection, but back to they need to wait a year to reapply for that same amendment request.
Unless there's new evidence, materially revised request, or proof of change conditions relating to the reasons noted for the denial. In any of those three situations, should they be present, an applicant could come back earlier. But absent that, the language would provide that it has to be a year.
So then we need to decide here tonight if that applies. Is that what I'm?
No, you don't,
That's
that's
not
not really a decision.
Right.
Chair.
All right.
That's not what he's come forward for. He's not asking us to get into an exception. He's asking us to interpret the ordinance to overrule some of the language that's in the ordinance. Specifically, what he's asking for us to do is overrule subsection C4, which requires the planning commission to approve the agreement as a condition precedent to the agreement going forward to council. That's really what he's asking us to do. His position is that the planning commission doesn't actually have the authority to hold it up, and that he has to be able to go to council immediately, regardless of our statutory language. Their argument is basically that our statutory language is wrong and shouldn't be followed.
And without waiting 12 months.
And that's one of the arguments. I want to be fair to the appellant. That's one of the arguments they raised.
So through the chair, I guess, is anybody making the interpretation that, I've heard some people make the interpretation that there wasn't a denial. Interpret that there wasn't a denial, but you follow our ordinance and you don't see it in conflict with the state law, is there an interpretation where they don't have to wait a year to return to the planning commission, but they do have to return until they receive approval, a recommendation to approve? Do you know what I'm saying?
I understand exactly what you're saying.
Yeah, no, that makes sense. too.
It's, what the question is assuming that they can't come to city council until they have that approval,
Right.
what can they do to get back in front of the planning commission in less than a year in order to at least try to get that approval so they can go on to city council? Can they do it? And I think that Attorney Christ was addressing this when he was talking about section 24-323D. If they could, if they submitted a materially revised request, if they came forward with a new request and said that there was new evidence that supported their request, that would allow them to get before planning commission again, or if they said they had proof of change conditions, if they could show these things, that in theory would allow them to come before planning commission again in less than a year. But what they wouldn't be able to do under the city's interpretation is they wouldn't be able to just resubmit the same request in less than a year. And the city's interpretation is that the failure to approve the motion, the failure to obtain a motion approving the recommendation is the same thing as a denial, and that without planning commission's recommendation of approval, it can't move forward to city council. So from the city's perspective, that's a complete barrier to moving on to city council. From the city's perspective, planning commission has got to approve it or recommend approval. They're not the legislative body, so they don't actually approve it. But the city's position is that unless planning commission recommends approval, you can never get to the city council.
But when else have we considered failure to receive recommendations?
Well, that's a good question. We can direct that to the city.
There's not a majority vote is what you're saying, so that's why if there was a majority vote, it would have been approved or denied. But right now, since it's equal, we don't have that.
Right, so there's no.
I think there's example, through the chair, but there's a lot of examples, for example, variance requests. A motion to approve a variance that doesn't get the requisite votes is a denial of the variance. Just, to bring it back to the Board of Zoning Appeals issues.
Right, okay, thank you.
Through the chair, so I guess using that same example of the zoning board, if we were to come in right now with our 1, 2, 3, 4, 5, 6 and pass a 3-3 vote, they would still have to wait 12 months to ask again, even though we didn't provide enough quorum to give a solid denial or approval. That's kind of what I'm stuck on.
So, Board Member Monk, your question is, if someone makes a motion one way or the other on this issue at the Board of Zoning Appeals level, and if it ends up tied up at the Board of Zoning Appeals level, does that essentially leave the appellant in limbo?
Yeah, so, yeah, the question is, would we require a 12-month waiting period if we were unable to give a majority vote one way or the other? I've never been in that position here, but
It's a good question, and we as the BZA would not, because we're not deciding on some of these issues. We're deciding on the interpretation of the ordinance. So we're 2 steps removed from the ultimate question, which is, should this be recommended for approval or not? What we decide doesn't actually tell any legislative body or the planning commission that they should recommend approval or denial one way or the other. We're performing a procedural function as opposed to a substantive function.
I appreciate you keeping me on task with that, because I need to keep hearing that to know why we're here and what we're actually deciding, because I find myself going off into other areas and don't even have to focus on that at the moment. So.
Right.
Through the chair, I mean, it is weird, on multiple occasions, I can think of at least 4, we recommended to an applicant to potentially table their request because we have, if they don't think they're going to get a majority vote for 3 years, to wait, because otherwise, just like in this case, and I don't know exactly how long it is for appeal, is it also 12 months? If it doesn't pass, if we vote and it doesn't pass, then they have to wait before they can appeal again. So I know that we've offered for people to table on multiple occasions, and I understand where Monk's coming from, where like this could put something in limbo, where even though we didn't cause something to have to last 12 months, we could still contribute to it lasting 12 months.
Right, and that's a good point that you make, Board Member Snyderman. With those things like variance requests and things like that, we are the actual decision-making body in those situations. Whereas here, we're not making the ultimate decision that's at issue with Council and Planning Commission. We're just looking at the language of the ordinance and deciding how that language should be interpreted. So,
If I could, just through the chair, that's exactly right. It's an interpretation question of the zoning ordinance that you're being asked to resolve, because there's an appeal of the staff's interpretation of the application of the zoning ordinance. So that's it's that appeal question of the language of the zoning ordinance that you're being asked to decide. And to the extent that the comment that sometimes boards propose or at least present to an applicant that they may wish to have a matter tabled because of an incomplete composition of their board makes sense, and I think that normally does happen to allow and afford the applicant an opportunity to have a full complement of the board with respect to issues that come before it. I don't know what happened in this particular instance or not, but I think as a matter of course, generally, I think the chairs of the Planning Commission and the BZA have raised that issue where there's just a bare minimum quorum of the Board of Zoning Appeals or Planning Commission to better afford that applicant an opportunity to have their matter considered by a full complement.
Through the chair to the applicant, were you present at the meeting where 4-4 vote occurred?
No, I was not present at that meeting.
Thank you.
Okay. I do actually want to raise that with the appellant, because we have an even number of people here. We normally would have 7 board members. There is an opportunity for deadlock on this interpretation issue. So we do offer this to anyone in a situation where we are down members, and I'm going to, of course, extend you the same courtesy. If you'd rather revisit this at a time when we actually have 7 members present and there's no opportunity for a deadlock, since you're here in an uncomfortable position because of a deadlock in particular, we would have no problem revisiting this in a month when we can maybe have 7 people here instead of 6 if you'd rather. But we are also happy to go forward if you prefer that we go forward. It's your appeal.
Yes, I think Mr. Aubrey would like to move forward with it, and I mean, it's, you know, and just one other point, I think in summary here, I guess we're just of the opinion that after having talked about all these other sections, we're of the opinion that really only G applies here, because we're not asking for all those other things. We're only asking to amend the agreement. That's all we're asking for. We're not asking for a rezoning or any of those other things. We're just asking to amend the agreement. And to us, it's very simple, and that's why it was written in there. If somebody wants to amend one of the conditions in the agreement, because there's like 25 or 30 conditions. It's not like he's coming in asking for, you know, all of them to be changed, so, you know, you have to go through a whole new rezoning. He's just asking one, there's a track record of his history there, and he's, you know, he feels comfortable going to city council and saying, hey, this is why we all agreed on this. Would you at least consider changing this for these reasons? And just the one narrow item, that's all he's asking for. And once again, it'll be discussed and so forth, but we're just of the opinion that only G applies. It says very clearly here what the process is, and we just want to follow the original process that we followed in the first place. You know, I respectfully will disagree with the city attorney. I think that process is appropriate. That's what all the other communities we work with do. Okay, we think that it should only be a recommendation from the planning commission to the city council, one way or the other, whether they want it or they don't. And then the city council can consider it. And if they don't want to, if there's reasons why they don't want to approve it, they don't have to. But we think the process is appropriate and it's fair.
I have one more question for you. There are 2 halves of this subsection. You've got the conditional rezoning agreement may be amended by the city council with the property owner's consent, but then you have a portion that says, in the same manner as was prescribed for the original rezoning and conditional rezoning agreement. Under your client's interpretation, should we just ignore that second half?
Well, I think maybe the real interpretation then and the difference was the original process that was followed the right process to follow. That's how all the communities that I work with, that's the process they follow. Once again, you go back to that whole legislative authority, just like you have legislative authority in the state act to grant variances. You're the final, you know, arbiter of those requests. But when you talk about rezonings, the planning commission just recommends the council can choose to listen to them or not listen to them, regardless of whether it's unanimous or it's, you know, split or it's for or against. It's always just a recommendation. And primarily what the city council should be looking for, what are the comments being presented by the planning commissioners? I mean, I know from my discussion with Mr. Aubrey, there was one planning commission member who said, I didn't want guns in here in the first place, I don't want them now. So it wasn't even a discussion of the merits of the request, it was just they don't like guns, and that person did not want guns. But that decision was already made, you know, 6 years ago. So now it's a question of what's the safest way to, you know, to deal with guns. So we think your process is good. We think it works. We just want to do the same thing that we did the first time around. And then if they let the chips fall where they may.
Thank you. All right, unless there are further questions for I'd open this up to general board discussion at this point.
Chair Williamson, we have another audience. The public comment at all, or is that completely passed?
Through the chair, it's actually our project planner, Christine, who you haven't met yet, but
Okay, that's why I
glad
know.
she could join.
Very well, hello. All right, never mind.
We do typically like to allow public input.
Right.
People aren't here right when the public hearing takes place. I appreciate you bringing that up. So I stopped you at one point, Board Member Palmer, so that we could finish with the questions. And you were at the point where you were going to make a point about whether or not a denial had actually occurred. I interrupted you right then, so I wanted to remind you where
Thank
you
you.
were.
It's interesting because I think there may have been one other time in all these years that we were asked to interpret something. And it's kind of uncomfortable for me due to the fact that I don't write these. And I just abide by them, all these ordinances and everything else. And to me, if it had to go to recommendation with a majority vote, 4-4 doesn't say denial in my mind. I mean, it's really difficult for me to understand that if it's only a recommendation, it's not an approval, just a recommendation. So whatever was said during that meeting should have some merit too. And shouldn't the council consider everything? So I'm just a little uncomfortable in having to interpret this. I'm not that legalese person, so.
If I may, through the chair, what Board Member Monk stated when he pointed out that it was 6 of us. I mean, I can recall at council meetings where there've been 4 of us. If it would have been a 2-2 vote, I think it wouldn't have passed either. It seems like that's kind of been the process. If there's no definitive yes in favor of something, then it's a no. It's just kind of where I'm thinking.
No, but I never thought of it
Right.
that way. That's all.
Chair, if I may offer sort of my opinion or the point I'm sticking on. The thing, when Board Member Palmer talked about being uncomfortable interpreting the law, the thing that I'm most uncomfortable with is the idea that this entire process, conversation, everything that's happening currently is taking place outside of earshot of council. And I understand everything will be in the minutes from all the meetings, but it's nice if all of our council members read all of the minutes to every
Right.
meeting. I don't think that's how they necessarily get things done. So, and the main thing is like, one of the true purposes of our board, which is laid out in the Michigan Zoning Act, since that's been such a focus of tonight, is that we are, we're a quasi-judicial board, and we are the last stop before somebody would exercise their other legal recourses. So with no other options available to an applicant process, their only other option becomes to exercise legal rights, in which case I don't feel it's responsible to put city council in a position. They then receive that, but they've had no awareness of any of the other of this process up until that point. So that's what I'm uncomfortable with in the whole thing. And so it's like, I understand all the different interpretations, but I feel like it's like we either have to interpret this as a denial, in which case then you do have to wonder who has the authority to deny, and was that executed properly, or it's not a denial, in which case they have continued rights with the planning commission, but we did kind of see to some degree that was a denial by the planning commission, but I'm not comfortable with the idea that city council's ability to read the minutes of the planning commission would, I guess, properly inform them.
Well, if I may through the chair, there is a city council liaison on the planning commission. So, and usually, typically, when things kind of come to council, which I suspect happened at that meeting that you referred to, Chair Williamson, that there were discussions, and usually that is the time when the city council member who is the liaison speaks up about it and talks about the vote and why it happened. So we don't necessarily read everyone's minutes, but every one of us has the opportunity, because we're all on some commission, to come forward and say, and state our case, why we voted the way we did, et cetera. Yeah.
So you feel it adequately informs.
And I can tell you that on some meetings, that even if I'm not the liaison on the meeting speaking just for me, that I'm listening in one way or another. Yeah.
I would point out too that the question as to whether or not it's really a denial. That's an argument that the appellant raised that I think we needed to deal with. I think it was a valid argument and needed to be discussed. But the city's position really is that if there isn't an explicit recommendation of approval, that this doesn't go to city council. So that's more the real kind of a choke point here in the process. Is the city's position is there has to be an actual approval by planning commission before it goes to city council. And the appellant's position is that this portion of the ordinance is not appropriate because it's essentially taking the decision away from a legislative body, because their position is that delaying it for a year is equivalent to forcing the legislative body to deny it, or denying it on behalf of the legislative body. That's what I see as the primary choke point in the whole process.
Yeah.
Putting these other arguments, which renders the other arguments a little bit less important. Not that I don't think they should have been raised. I think the appellant did a good job of identifying multiple different issues that could support their position, but it still comes down to the same issue of the city's saying if there isn't an explicit approval, it doesn't go forward.
May I address a question to the appellant?
Of course,
Appellant,
yeah.
appellant, I can't even say the word.
You might want to just linger by the podium, because I imagine
Okay.
this is going to be the only additional question people have.
Okay, no, not a problem.
Okay, so bear with me here. Before, I felt that you were sort of questioning that Ferndale law, which is superseded by state law, was inappropriate in relation to state law. So I just want to restate a few things, and then I'm hoping you can help me understand where you were going with that. So as Chair Williamson just said, under 24325C4, the language is "and recommended for approval by planning commission," recommended for approval, nothing about denials or breaking even, says specifically recommended for approval. You said C4 didn't apply, but under 24325G, as also Chair Williamson said, the second half says, as was prescribed for the original rezoning and conditional rezoning request, which to me does point back to C4, saying, and recommended for approval by City Council. But when you look at, you brought up MCL 125-3401, provision 5, which calls back to provisions 1 through 4, and in provision 3 it says, the legislative body may refer any proposal amendments to the zoning commission for consideration and comment within a time specified by the legislative body. So I feel like that gives leeway for the Ferndale Code to say, yep, we want to hear what the zoning commission says, and then clearly it says zoning recommended for approval by the planning commission, zoning commission, whatever you want to call it. So, okay, so now my question to you is, can you help me walk through where, I can't remember exactly how you worded it, but something along the lines of MCL 125-3401 says it all, and I'm probably totally misstating that, so I apologize if I am.
Okay, well, when you go to the state law, okay, in a rezoning request of any kind, it's always a recommendation from the planning commission to the council, regardless of what that recommendation is, okay? So But taking that a step further, in section G here, maybe that's where we have a differing of interpretation. When I read and say, in the same manner as prescribed for the original rezoning, I'm thinking of the process we went through. That's the process we went through. Now, if the decision is that that process was wrong, that means you're interpreting the ordinance differently, the wording here differently. I'm interpreting it that you're gonna have us do the same thing we did the first time around. Not that we have a different interpretation of the ordinance now.
So, through the chair, I need to look this up, but I'm assuming prescribed means the written direction on how to do something, and maybe that's not. And you're saying that the word would be more attuned to the actual outcome of what happened.
Mr. Chairman, the actual process we followed. We're going to follow the same process that was originally followed in the original rezoning. We're not going to change it. And this is another thing that when you get into planning practitioners, one of the things that we always consider to be important is to be fair and consistent with applicants, okay? Which means, and in this particular case, we're just looking to follow the same process we followed before, not to have the rules changed now because we want to ask for one of the conditions to be amended. So that's why when we look at this, we're just saying, look, we just want to follow the same process. That's how we read this. Not that we're going to now look at the ordinance in different sections that don't deal with the conditional rezoning, the conditions. We're going to look at that original section that dealt with the original rezoning, and now we're going to interpret the process differently than when we went through the process. So we're just looking for consistency here, and that's how we interpret this.
So, through the chair, you said, and I'm probably misquoting, so I apologize. You said all applicants need to be treated fairly. So if you had one mistake, and you're saying we want to go under the same mistake as before, but every other applicant had been doing it appropriately, which would be more fair, to follow the way the other applicants had to do it, or to follow the way, the one-off that you had experienced?
Well, I think I've gone through minutes year after year after year, and I don't know that you've had any other conditional rezoning requests where there was a recommendation for denial that went to city council. I think we were the only ones. Okay, so there isn't that history of, well, we've always done it this way and we made a mistake in your case. The way I'm looking at it is, I think the course we followed was accurate and correct. And I think that it's appropriate, and it's appropriate under state law. And I'm just saying that, and really, once again, it still just comes back down to that 12-month period. And, you know, we're just looking for it to be treated fairly here, to follow the same process we originally followed, and have an opportunity to go to city council, let them make the decision.
If I may, through the chair, so what you're referring to is that there's nothing in the history that there's been a direct split where it was considered denial, but there have been many, many times when Planning Commission has had a overruling majority vote that it did not come to council because it did not pass.
Mr. Chairman, the only ones I saw, the only conditional rezonings that I've seen move forward were recommended for approval by the Planning Commission. The only one that was recommended for denial was ours, and then it went to City Council, and then, you know, the conditions were changed, and the City Council approved it. So we're the only one that had a recommendation for denial and went to City Council. So we just want to follow the same process.
Okay, so through the chair, it's my understanding that Planning Commission denied you, but you still went before our council.
They recommended denial.
Feeling that right now the 4-4 vote is a denial, which we're being told that's what it is. You want to go before the council again?
Mr. Chairman, okay, 2 points. First of all, it was a recommendation. You know, we're talking about approval or denial. The Planning Commission does not have the authority to approve or deny in this case. It's not
I
state.
understand, but you said it the first time you used the word that they denied.
They recommended denial in the City Council,
Right.
yes. And
But you still went before the council.
yes,
Okay, and at that point, you were allowed to present to them,
yes.
and they made their decision based off of what you told them.
Correct,
And the
There were
changes
amendments.
that, the additional conditions.
yes.
With the additional conditions. So now, because as of recently, the 4 vote is basically denying a recommendation, you'd like to go before the council again? But what we're being told is that you have to wait a year.
So
He wants to skip the beat for you to go before the council and see if you can get that amended, your conditional approval.
Mr. Chairman, first of all, in any zoning realm that I deal in, the only time a 4-4 is a denial, a tie vote, is when you have final approval authority. If you're the zoning board with variances, if you're, planning commission with site plan, if you're whatever. But whenever it's a recommendation, it's not considered, a 4-4 tie is not considered a denial because you're only recommending. So your recommendation of 4-4 or whatever it might be goes to the approving body as a vote went through, along with all of the comments. So it's not really a denial, it's a recommendation. And it wasn't even a recommendation for denial, it was a tie. It was a 4-4. Half the people thought it, and half thought it didn't. Right.
Okay.
Through the chair, the way I'm hearing you, even if it was a 1-7, you're saying that recommendation should go before council?
Correct.
Okay.
Thank you.
Essentially, the issue here is that we have a statute that says the planning commission should stand in a gatekeeping role, and that only when the planning commission recommends approval should the request go to council. In this situation, which I think everyone acknowledges, last time around for this specific conditional rezoning, that gatekeeping function was not followed by planning commission, and they were permitted to go forward to council after the planning commission had recommended denial of the conditional rezoning approval. And that's where it's unclear as to how or why that happened. But I think no one disagrees that that is in fact what happened here. Board Member Steineman.
Chair Williamson, in the past, we've always brought up the fact that if we allow variances, anyone in a similar situation would be able to jump on board that variance and also request and not be denied that same variance. If we were to interpret this to where we send it through, would anyone who at that point didn't have an approval by city council now be able to force it through based on our ruling straight to, I'm sorry, not approved by the planning commission, thank you, yes, I'm sorry. Not approved by planning commission, they'd be able to come in and say, oh, we want the same ruling and we want to send it straight through, even though it wasn't approved to city council. Would this be changing, in essence, the law?
For conditions that are specific to this situation, I don't believe that to be the case, and here's why. We have language that says the conditional rezoning agreement may be amended by the city council with the property owner's consent in the same manner as was prescribed for the original rezoning. So if this original rezoning is interpreted to mean the original rezoning of this specific property, then
okay.
that would mean that he would get to go through using the same process that was originally used for this property. And if that were consistently interpreted for every property owner out there, that would mean that when they first came in for a conditional rezoning, whatever the process was that was used for that property, that would be the same process that they would go through for an amendment. But it would not, for example, prohibit the city from properly applying the language as drafted in the ordinance the next time around when someone has a conditional rezoning request. If it's denied, not sending it to council, which apparently they did last time.
Okay.
That's the interpretation I think that the appellant is looking for. The other countervailing interpretation is for us to interpret this as referring to the original rezoning back to the process as set forth in the statute. But and then everyone's going to have to make their own determination on which of these interpretations they think is more appropriate. But for that reason, the interpretation they are looking for is not an interpretation that requires, that changes the law.
So follow-up question would be, in the past, we've added criteria to make sure that the specific requirements were met. If we were to allow this today, could we make specific requirements in our, I don't even know what this is called, because it wouldn't be a variant, it's not like we're motioning for a rule change, right? Would we be able to say only applies to applicants that had basically had that happen, where they went on with a denial to city council?
That would actually be inherent in the interpretation. 'Cause
Okay.
our interpretation would be that the language that says, in the same manner as was prescribed for the original rezoning, is a reference back to the process that was used for the specific property at issue that was conditionally rezoned. So that interpretation necessarily ties every property to the process that was used when the initial conditional rezoning of that property took place. Does that answer your question?
Yeah, I think so.
Okay. So what that interpretation does is it kind of puts the onus more on the city that planning commission and council need to properly interpret the ordinances. And if they don't, they're locking themselves into allowing someone who gets a conditional rezoning through a process that is not statutorily correct, can continue to benefit from the process that is not statutorily. But, the countervailing interpretation is, as I said, that original rezoning means the original way that rezonings are supposed to be handled, which takes you back to the process in the statute. So that's kind of what it boils down to here. Do we interpret this as the original rezoning, meaning the way things were done with this property, or do we interpret the original rezoning as the way things are supposed to be done as set forth in the statute?
Mr. Chairman, if I could ask a question, is kind of putting on more of just not consultant, but planner hat. With other rezonings in the city, if there are recommendations for denial, do you not send them on to city council?
That's something you're going to have to take up with planning commission.
Yeah.
Unfortunately, we don't have our planning commission liaison.
Yeah. No.
I spent some time in that role. I can tell you during the 5 years that I was on planning commission, I don't believe we had a denial of a conditional rezoning that was sent on. I don't recall that taking place. I think this one happened immediately before I became the liaison to planning commission. Because I recall some of the discussion around Motor City pawnbrokers moving to their location that they're in currently, but some of this slightly predates me.
Right, yeah, I'm thinking more of just straight rezoning, it's not conditional. Because it's kind of the same concept, and, you may go back and amend your ordinance to clarify it, which is probably a good idea anyway.
And amend anyway.
But, I mean, in any type of rezoning, regardless of this case or other, I would never recommend that you have the planning commission be a gatekeeper that keeps a rezoning request from going to council. That's just, I don't think there's any statutory support for it. It's really not done anywhere.
Yeah, I understand your position on that.
Right, and through the chair, that's not, I will indicate that that's not done with respect to straight rezonings.
Right.
Recommendation, affirmative or negative, still goes on to council.
Yeah, this is a pretty, the conditional rezoning is a pretty specific issue that doesn't come up.
Okay.
We have further discussion amongst board members.
Follow-up question to that first.
Sure.
Say we do it differently for like a straight rezoning versus a conditional rezoning. You go So your interpretation of the state law, the Michigan Zoning Enabling Act, supports treating those circumstances differently?
Through the chair, I think it's within the discretion of the legislative body, which is the council, which adopted the language of the conditional rezoning ordinance.
Ah, I see, thereby sort of granting their power to approve or deny in certain.
Right. Right.
Yeah.
Well, I mean, if you were inclined to make a motion,
Not recommended.
yeah, and that's a good point, because I got planning commission.
Not recommended.
Was not recommended for approval.
I wanted to make sure. Right. Oh, no, that's why I'm saying, it's just, I wouldn't want to do that.
Right, so if anyone is inclined to make a motion either way on this issue, language set forth as the example refers to the conditional rezoning application being denied at the planning commission. Any motion should clarify that the conditional rezoning application was not
A lot of words of denial in that paragraph. And I'm sorry, I just can't use it. Because we're being told that it wasn't denied. First paragraph.
I'm ready to make a motion if you're through the chair. If-
Sure, yeah, it looks like there's not further discussion at this point. Table?
I'm, I move that the Board of Zoning and Appeals affirm the city staff interpretation of the article presented, section 24-323 procedure, that since the conditional rezoning application was not recommended for approval at the Planning Commission, the application shall not be resubmitted for a period of 1 year from the date of the non-recommendation, except on the grounds of new evidence, materially revised, request, or proof of changed conditions relating to all of the reasons noted for the non-recommendation found to be valid by the Planning Commission.
Right, we have a motion on the table from Councilmember Leaks May. Support and/or discussion? Hearing no support, does anyone have a countervailing motion
Through the chair, this all comes down to the 1-year waiting period. And that's what this motion says.
Well, this motion is asking to affirm what the city's interpretation of the ordinance is, which is that failure to approve is a denial. Failure of a recommendation to approve prevents it from going to city council. Then it can't go back in front of the planning commission for another year. All right, support by Board Member Blazinski. Any discussion as to the motion?
So if I could just give the reason I supported the motion. Just going back to what, said, in regards to a conditional rezoning, not having, the inherent rights of some other types of applications, being that, conditions to a rezoning are something that are offered by the applicant as a condition for the approval. And so that's where I fell when I decided to support that. While I may come to a different place if I was viewing this specifically as a rezoning, which it is not, it is the applicant asking to bring their conditions back to the table as an amendment, which in our city statutes, the council has clearly laid out their intent for planning commission to act as the gatekeeper and
Thank you for the explanation, Board Member Blazinski.
I appreciate that too.
Additional discussion of the motion?
May I ask a question, non-motion related?
Sure.
Can you, what's the meaning of material? For them to come back, they had to have a material, what was the word?
Grounds of new evidence, material, revised request, material, oh my
Yeah,
God.
what constitutes a material change? For for them to come back.
It has to be more than just a tiny little change. It has to be a change that actually changes more than a nominal change. It can't be a change that is designed to achieve the same outcome without any actual alteration. You can't slightly change the wording and come back and say, okay.
Unless they have new evidence, revised request for proof of changed conditions.
I see no further discussion on the motion.
Board Member Palmer.
Yes.
Member Steidemann.
Agree, yes, and Chair Williamson has asked that we give our rationale to help in case this ever comes up. Between 24325C4, 24325G, 125-34013, 125-34015, the circular logic to me keeps coming back to the word prescribed, and the applicant's description of prescribed meaning what actually happened, whereas I'm interpreting prescribed to be what was written, and particularly what was written in 325C4. And so because of that, and also because Motor City Pond has been in here before, I believe in October of 2018, and we actually passed a variance for them in terms of signage going from allowing them up to 50%, which was significantly higher than the 20% allowed. I am agreeing with that, with the motion.
Member Blazinski.
Yes, I believe I stated that.
Councilmember Leaks May.
Yes.
Member Monk.
Yes.
And Chair Williamson.
Williamson, Jordan. That's okay. This is a tough one for me, because I do understand the interpretation that the applicant or the appellant is using here. And there was an original rezoning process here that clearly was not carried out in compliance with our statute. That said, having weighed the two different interpretations of prescribed in my mind, and having reviewed multiple different examples and discussions of both, I'm tending to fall down on the same side as Board Member Steidemann on this. Prescribed is better employed to mean the written instruction, such as what we have in the zoning ordinance, more so than the process that was employed for this original rezoning. I think that, so my vote on this will be yes, to also affirm, but I think that this is a kind of a cautionary tale for the city as far as planning commission and council, and paying attention to what our zoning ordinance requires when these issues are moving between the bodies. Because what happened in this case is not what the zoning ordinance requires. And if what had happened in this case had been what the zoning ordinance required, we wouldn't be here again on this request. Although, you know, in that sense, Motor City Pawnbrokers still comes out the winner either way, because perhaps Motor City Pawnbrokers conditional rezoning never would have been approved in the first place. So, with that said, the motion to affirm staff's interpretation passes by the vote of all board members present. To the appellant, we thank you for your time. Thank you for presenting your arguments and spending the time to answer all of our questions. It was very helpful in understanding the position, and this was a difficult decision vision for everyone clearly. But we appreciate it.
Thank you.
Made some great points.
Yeah, I'm glad that you're with us today.
Yeah, it was
Councilmember.
clearly,
Something that would be,
yeah,
that would be good for, brought back to council's attention.
definitely.
That happened. So with that, that takes care of all of our regular agenda items, which moves us to item number 6, administrative items. So I'll turn it over to you, Justin. Do you have any administrative items?
Thank you. So mostly just wanted to provide a quick update on the master plan, Parks and Recreation plan, and climate action plan, which all falls under the Plan Ferndale umbrella. So at each of your seats, there was a poster for an upcoming 3 sessions, what we're calling a virtual summit, that have 3 specific topics. These sessions will be recorded, but they will be October 26th and 27th. If you can't make it, they'll be recorded, posted on this Plan Ferndale project page that we have here. If you can't make it, totally understand. Please, I'm just asking folks if, tell one friend, one neighbor about it, and I think, that could be very valuable. Share it on Facebook if that's your thing as well. But we've been putting signs up around town, sharing things on Facebook, contacting specific boards, commissions, groups. I'm speaking with the library board on Thursday, so trying to promote it as many ways as possible. But it always helps, I think, just to have our, active volunteers share with neighbors. So there's a lot of other things that I won't, get into details too much on, but, this is kind of the beginning of the community engagement process. So this is our first big, community-wide meeting. There's going to be a lot of other opportunities. We also are, asking folks to invite us to your neighborhood groups, and we'll do some sessions on, or a session, and hear from folks and get feedback that way. 'Cause sometimes I think those smaller groups, it's very valuable to get that type of feedback. So we do have various links on this project page where you can request us to come and do a small group session at your neighborhood group. So we just got our first one last week, so excited to plan that. We have other things coming up, like an online survey and some other things, but really we're focusing on the community summit next week. So if you're able to attend, great, and if not, we hope to see you at a future event. So that is really the primary update for me tonight. So, but thanks a lot for your time. I think the conversation was very important and technical, so I appreciate Attorney Dan Christ here as well. And I think it just shows how experienced our board is. And I think finally tonight I can answer a question that one board member's asked me at many meetings over the years. And so I just want to appreciate board member Palmer. She was first joined the Board of Zoning Appeals January 24th of 2000. So that is pretty amazing for a volunteer. So just wanted to say thank you. And thanks for reminding me to dig into the history on that. So.
Will be upon.
I keep saying 28, so it doesn't matter. It's all right.
More than 20 years continuous service on the BZA.
Yes. Thank you.
I appreciate that, Justin. And that takes us to item 7, board items. Any items from board members?
I was just going to introduce myself. Good evening, everyone. My name is Christine Ross. I'm the new project planner here with the city. I've been here for a little over a month, so I apologize for being late. I was finishing up an online class. So hopefully I can work with all of you a little bit more when I don't have class on Tuesday nights. So it's good to be here and nice to meet you all.
Thank you for joining us tonight.
Thanks.
It's good to see you.
Very rare do we go really late, though.
Don't say anything like that. I don't want to hear any comments.
Tell you, I've had to say in the past. I'm sorry, it's past my bedtime.
No, believe me,
I
after
know.
5 years of planning commission,
I know.
anyone saying things like that about zoning board. We are not going in that
Okay, good. So by 9 o'clock, we're out of here every night, every time, right?
Just stop jinxing us.
I'm not saying anything.
So, any other board items before we move to adjournment? All right, thanks again, Dan Chris, for joining us tonight.
My pleasure.
As always.
Yeah, thank you. We
And,
appreciate it.
With that, we'll move on to item 8, adjournment. We will adjourn at 8:59 PM.
Ian, did I call you Williams multiple times tonight? Did I call you Williams multiple times?
You know, I couldn't even tell if people were saying Williams or if just because people had masks on, that they weren't saying
Well,
Williams.
I just heard you say it, and then I was like, shoot, I've been saying it this whole time, like, my mind was trying to work so hard to keep up
You
with
keep
this.
saying through the
Thank
chair,
you.
so it's not
I knew you probably
necessarily
had
that
it,
you
so.
say the last name,
Oh,
so you're okay.
well, a couple times I
Thank you.
called out, you know, him asking for certain things and why I was doing things.
It's a common slip that people make, that we try to correct people on it very quickly, for the same reason you corrected us on Steidemann, which I appreciate.
Cinnamon.
Steidemann,
I know that, I know that.
It's common, but it's
That's
also,
it for a reason.
I feel it.
Yeah. No, well, I apologize if I did that.
You're so good at interpretation.
It's too much.
Well, it helped me understand things
No,
more.
the reason I-
It helped me understand that
I wanted
there was
to
a
make sure
major
you were
flub
writing my name right.
years ago.
Ah, gotcha.
I thought you said Williams, but it may have been because you had Okay, that's what it was. I wasn't sure.
I thought you were telling me not to ask him his chair. I was like, oh, man.
Oh, no, I just wanted to make sure that you were putting Williamson and not Williams in the notes or the minutes. That's all.
My dirty secret is
That's a good point, actually. That helps.
Nothing wrong with that. Saves time.
That's right.
All right, well, Jordan, thanks again as always.
Yes.
Appreciate having you here to,
Oh, also, I got your email about the precinct inspectors. I have a mediation hearing that same day, and I won't be able to do it for the first time ever. However, it's in the morning, so I was just wondering if there was some leeway that if I could come and maybe if there's time in the afternoon to
You had a
help,
couple
I
of
will come
questions
do
that really
that, but in the morning, I'm,
incisive,
I'm,
and it really got down to
yeah,
the root of some of the issues that it was
okay,
hoping that people were pulling on.
okay,
if I was,
right.
Totally taxed it.
I don't know. That's not an easy job.
Yeah, I imagine. Okay, all right.
we've had it